Welcome. We are visiting the values of the Constitution of India. We have conceived a project in the form of a case study in reference to the three books of Justice S.D. Anand, and further our privilege to have expressions of Justice S.D. Anand as well with respect to our queries and all that. The Constitution of India has a specific chapter with respect to the subordinate courts. The subordinate courts superintendence on administrative as well as on the judicial side is completely vested in the High Court. Public in general and even the lawyers and the law faculties and other persons otherwise interested and involved in the legal processes are highly ignorant about this chapter of the Constitution of India, particularly in respect of the superintendence and control of High Court upon the subordinate judiciary on administrative side as well as on the judicial side. As far as the judicial side is concerned, the Article 226 and Article 227 are invoked frequently. However, still the aspect of the administrative control of the High Court upon the subordinate judiciary as such is bypassed. It is this ignorance of the general public, litigants in particular, and liars especially, is such an aspect which deserves to be focused. Much light deserves to be thrown upon this closed proceedings chapter of the Constitution. When one will ask to oneself as a lawyer or as litigant or general citizen having some interest, some interaction, some involvement, some participation in the judicial proceedings, that how much we know what are the service conditions, what is the law, what are the expediency circumstances of the judicial service cadre. Start from the appointment, the postings, transfers, leave, annual assessments, promotions, postings, inquiries, complaints from the public, complaint from the litigants, complaints from the witnesses, complaints from the liars, complaints from the prosecution branch, complaints from the administrative authorities, and complaints from other incognito complainants, or the facts and circumstances of a reality of the service conditions of the judicial officers, which are little known. Even if we ask the lawyers having a good number of years of practice as to how much they know about the service conditions of the judicial officers, perhaps the answer will be practically as of an ignorant person. When we are considering the human factor of the judicial systems, justice delivery system, justicing the ideals of the Constitution of India, then certainly we are not doing our duty to remain ignorant about this aspect as well. I'm conscious that it is not only the judicial officer with respect to whose conditions one is to be alive. Same way, the public prosecutors, the investigating officers, the court staff, the lawyers, and all other persons who are directly and indirectly involved in the judicial process, or the individual fact participants with respect to whose service conditions deserve to be elaborated. It is the enlightenment, it is the knowledge about these situations which will certainly enhance our efficiency, and it will further add to the values of the justicing which we are having a necessary evil with us, or necessity of the reality with which we have to live. Today, the aspect which I am focusing is the chapter of the Constitution of India of Articles 233 to 237. The books of Justice S.D. Anand, as these are giving many instances of the way the judicial officers are coming face to face with this administrative control provisions of the Constitution of India. The human factor of justice systems takes us straight to the subordinate courts chapter, the superintendence powers of the High Court on administrative and judicial side with respect to the service conditions of the judicial officer, as well as the judicial outcome from the courts of the judicial officers. Now, the administrative superintendence is the aspect with respect to which there is great ignorance among us all concerned. The concept, theory, practice of full court and of annual courts inspections and the annual reports of the individual judicial officers is the domain with respect to which we have to be fully conscious while we shall be progressing with the present case study of Haryana judicial setup. In reference to the instances mentioned by Justice S.D. Anand in his 3 books, and further, this domain deserves to be explored fully in the light of such expressions coming in public domain from other authors as well. In this respect, when we shall be having our evaluations, we have certainly be confined to the outer domain settled on the judicial side within this domain. Let us visit this domain, the administrative window through which we have to look is of the superintendence and control provision of the Constitution upon administrative courts of the High Court. These judicial officers are human beings. The judicial officers are in active service under the service law and rules. These judicial officers, as human beings, are concerned regarding their transfers, postings, complaints, and all other connected aspects. The judicial officers as litigants is a unique class of litigations and litigants. Little public knows as to how the judicial officers as litigants are being treated vis-a-vis the other litigants. The judicial officers' litigations as a class is of absolutely distinct features, distinct values. Moreover, when the superintendence of the judicial officers is with the High Court on its administrative side, and the judicial litigations, adjudications as well are to be through the High Court on its judicial side. It is this feature which makes the judicial officers litigants as a unique class. This class of litigations is such class of litigations that we deal as lawyers, as legal exponents, as law scholars have to attend. We have to be through the judicial decisions in case of litigations of the judicial officers. Once we are anxious, we are desirous, once we have an urge, once we are on the process of the chase of human factor in reference to Haryana state judicial setup, and once we are going to have a reference of these books of Justice S.D. Anand, then we shall make enlistment of the instances mentioned in these books as to how the judicial officer in chair and in having discharge of duties comes in contrast views of the litigants, lawyers, prosecutors, administrators, administrative judges, the dignitaries, and the Chief Justice of the High Court. Once we will be having a tabulation of these all instances, and once we shall be classifying them, and once we shall be having outsiders view of these insiders' expressions, then certainly the need will be that we shall have simultaneous exploration of the judicial pronouncements so that we may acquire a proper perspective for appreciation and evaluation of this domain of the human factor of justice delivery system. As we are planning, as we are proceeding, as we are conceiving, as we are considering, as we are chasing Haryana judicial setup, so we shall tabulate the total judicial officers litigations since 1966 till date, and then on the basis of the judicial side pronouncements in such litigations, and it is in terms of the same we will be having a proper perspective of appreciation of justification of such provisions in the Constitution of India, and also we will be in a position to have a critical view of the reality of such provisions. The evaluation of performance of the individual judicial officers, their annual reports, the evaluation and consequential promotions, and also having the impact of such evaluations even upon transfers and postings, even upon the choice of particular officers for particular class of litigations on judicial side, and even for the administrative side, administrative cadre postings of the judicial officers. From the expressions of full length service period of Justice S.D. Anand, it clearly comes to focus as that the judicial officer is to sequentially grow and is to acquire the responsibilities starting as judicial magistrate second grade to judicial magistrate first grade, chief judicial magistrate, additional session judge on criminal side, and likewise one is to sequentially acquire the responsibilities of the civil judge junior division, civil judge senior division, and the additional district judge and district judge. Then one is also to discharge the responsibilities as of district and session judge vigilance, as legal remembrancer, and as the registrar. These all responsibilities as such are to be acquired, but these are to be bestowed with the discretion of the High Court, which is vested with the constitutional responsibility of continuous superintendence and control. This continuous superintendence and control of the subordinate judiciary is vested in the High Court by the Constitution. This constitutional responsibility is of such delicate nature that at some points of time, in some instances, it may appear as if there is going to be a clash between the administrative discretions and the judicial uniformity rule of service. However, as we are having this case study as a project with an aim to have full imbibing of the realistic situation as human factor component of justice delivery system. So we shall firstly approach these instances as these are mentioned in these books of Justice S. D. Anand on their face value, then to satisfy our urge, our queries, our quest about these very instances, then certainly we have to explore further. And for it, we have to go to other information in public domain. And still further, there will be need that we shall search for the relevant documentation in public domain, particularly the judgments on a judicial side in respect of these very instances as have been mentioned with focused attention in these books. The new aspirants of judicial service, a word of caution for them is that they shall firstly take a very conscious decision to join this service, as it is a service of an extraordinary circumstances and is of extraordinary attention of the Constitution of India. And this service has been given absolutely new eye for its vigilance. So judicial service aspirants have to be very, very conscious as that they are going to opt for discharge of the service which is of the responsibility of exercise of judicial sovereign domain. Each and every court at all levels is exercising judicial sovereign powers. The Constitution, while on the one hand describes it as a subordinate judicial service, the same on the other hand as stands interpreted by the Supreme Court as that each and every judicial court is exercising judicial sovereign powers. So while a judicial officer occupies a judicial chair, then from that very moment of occupation of that very chair, he becomes a sovereign. Once one is under an oath to act as a sovereign, then certainly he has to have equal transcendental transformation of his intelligence, consciousness, conduct, and all other aspects. He, as human being, acting as sovereign, is certainly a phenomenon which deserves to be imbibed consciously. All those services, other than that of a judicial service, is having one this distinctive feature, and this distinctive feature is that here the expectation of the Constitution, the interpretation of the Supreme Court, as that each and every court is a judicial sovereign, then natural expectation is that judicial officer as human being is capable of transforming himself as of different values. The human factor of which we are having a focus in the present study, that way confronts us to be face to face with whether the human beings are capable of acquiring transcendental features. So, judicial officer, if is not capable of physiology, psychology, and all other mundane aspects for their potentialities to transform as of a transcendental content and as of transcendental role and as of a transcendental being, then certainly one is not to opt for this service. Now, beginning with human being, contributing human factor, and going to the level of the potentialities of transformation of human beings as transcendental beings is a very big domain. Therefore, my humble request is that all those who like to be a judicial officer, all those who want to opt for judicial service, shall first sit comfortably, have introspection, have a complete dialogue with oneself, have full, conscious, honest introspection for the interpretation of oneself, and then and only then one shall opt for this service. If we will be through the different instances mentioned by Justice S.D. Anand in these books are evaluated, then one will be highly realistic about what are the expectations of a judicial service and what are the restraints and constraints under which one is to serve. These instances will further bring us face to face with as to how judicial officer as a human being having human bonds with his family and all other beings of his relationship, he even may have to beg a transfer. He even may have to beg a posting. He even may have to look towards the administrative authorities of the High Court for all these very, very small concessions. Therefore, my humble, very, very humble request to all those who are aspiring for judicial service shall have deep introspection, and only when one feels that one is prepared for this sacrifice, one is prepared for this exclusive zone of functional in a transcendental way, then and only then one shall opt for it. And simultaneously, it certainly comes to a focus that all those who acquire the constitutional responsibilities as superintending judges over the subordinate service also shall have a very, very conscious introspection as to whether they are having that godly powers to evaluate the transcendental values of the judicial officers. It is in this background that we shall proceed further with other steps present case study. Thank you very much.